You are Juan Jose Serna.
Yes, sir.
Mr. Serna, you now stand charged yet again with burglary of a motor vehicle.
Welcome back to another intense courtroom breakdown, and let me tell you, today's session is absolutely JW dropping. We got a repeat car burglary with a rap sheet, so long the judge literally runs out of breath reading it. We're talking 20 plus charges, including burglary, theft, robbery, assault, and evading arrest. This guy's criminal history is like a greatest hits album of bad decisions. But that's just the start. We got someone who fired 2 gunshots inside an apartment while drunk and high, a woman facing terroristic threat charges for making finger guns at her neighbors, and multiple bond violation cases where defendants are pushing every limit the court has set. The judge's patience is running thin, and when he says it's either dead or 50 years, you know things have gotten serious. Home confinement, ankle monitors, SCRAM devices, no contact orders. The court is pulling out every tool in the book today. Let's dive into this chaos.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 20th, 2025, law enforcement officer was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County, Texas. A law enforcement officer spoke to 2 witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of a parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to her motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect saw her walking up, jumped out of her motor vehicle, got into the passenger side of a waiting vehicle with an unreadable plate, and the complaining witness then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes, Your Honor. Yeah. The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to.
So Mr. Serna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr. Stern is the second. Looks like the second individual that was in the passenger, that was in the driver's seat whenever the complaining witness came out of the vehicle, is not the owner of the vehicle.
Judge, if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's 2 people in the vehicle. The camouflage hoodie was not on my client, so I'm saying that there's no probable cause.
They have both of them in the car, being car.
The both of them in the car?
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
Were in the car attempting to.
I have
Because I thought it read that one person wearing a camouflage hoodie was in the car.
That was the second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off. Mr. Serna, let's go through your stuff. Theft of wire or cable. Theft, trespass, evading arrest, burglar of a motor vehicle, theft, assault of a family member, attempted burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal.
Okay, we need to stop and let that rap sheet sink in, because what we just witnessed is absolutely staggering. The judge just read off over 20 charges against this one individual, and he wasn't even done. Let me break this down. Theft of wire or cable, regular theft multiple times, trespass, evading arrest, not once, not twice, but multiple occasions, burglary of a motor vehicle, for separate times at minimum, assault of a family member, unauthorized use of a motor vehicle, 3 times, assault charges that escalated to felonies, robbery, tampering with a government record, felony theft, and now he's looking at even more open cases, including another unauthorized use of motor vehicle, felony theft, and burglary. This isn't criminal history. This is a career in crime. And here's the thing. The defense attorney tried to argue there's no probable cause because the camouflage hoodie wasn't on his client when they got pulled over. But both individuals were in that getaway car with the camo jacket in the back seat and a flat-pointed screwdriver, the exact tool used for breaking into vehicles. When you have this kind of history, the court's patience is completely exhausted. What do you think should happen to repeat offenders like this?
What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you muck with the wrong person, they're going to shoot your ass dead. It happens time after time.
Judge, he's due in felony court tomorrow for his felonies. His bond is currently set at $10,000 for this misdemeanor. Can we reset till Friday to see what happens in felony? I'm asking the court to not revoke his bond. His bond is set at $10,000. I'm asking the court to just keep it in place.
So there's nothing for me to revoke because he has not made bond on
In felony, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. If I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Sonner. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a SCRAM monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Who got the co-defendant? Do we have the co-defendant? No contact with the co-defendant, please, Felicia.
Still loading, Your Honor. I apologize. We have the co-defendant, Your Honor.
Say it again?
We have the co-defendant. I'll sit on the court seat.
Let me ask you this. You ever had a job before? Like a full-time job?
Yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years.
This is the moment that hits different. Did you catch what the judge just said? It's just a matter of time, dude. It's either dead or 50 years. Let that sink in. The judge isn't being dramatic. He's stating the reality of where this path leads. And then, life's too short to live in a 6x9 box for the next 50 years. This is a judge who has seen thousands of cases, who knows exactly how these stories end, and he's laying it out in the bluntest terms possible. He even pointed out the Houston reality. People like their guns and they like their cars. When you muck with the wrong person, they're going to shoot your ass to death. That's not a threat. That's a warning. Car burglaries in Texas have led to fatal confrontations more times than anyone wants to count. And here's what the court is doing in response. NO bond on at least 2 felony cases. Home confinement if he somehow gets out. Ankle monitor. SCRAM device to monitor alcohol consumption. No weapons. No drugs. The judge literally said this defendant scares him. When a sitting judge uses that word, you know the situation is serious. The underlying message is clear. At some point, the court runs out of tools to save people from themselves.
All right. Good morning, ma'am.
Hi.
Just a little bit down so I can see your eyes.
Sure.
That's okay. How are you?
Good.
Ma'am, you've not picked up another case. You're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Judge, if I can just confirm the name.
Agbasieli.
On April 1st, 2025, a law enforcement officer was dispatched to a residence in Harris County, Texas regarding a disturbance. Law enforcement officer made contact with the second complaining witness who stated that he was inside the apartment when he heard the first complaining witness outside getting yelled at by the defendant. The second complaining witness went outside to see what was going on, and the defendant yelled at him to stop putting things in the pothole in the parking lot. The second complaining witness told the defendant he was fixing the hole. And then threatened both the complaining witnesses, pointing at them with their fingers, making a pistol shape with their fingers, saying, "I'm going to shoot you."
Wait, you said there were 2 complaining witnesses.
Yes, Your Honor.
Okay.
That's what I have here. It says, "I'm going to shoot you," towards both complaining witnesses.
And we have Ms. Agbasieli making the alleged threats.
Correct, Your Honor.
Yeah, there's only charges one.
There's only, yeah,
Right.
yes, Your Honor.
Okay, who is the complaining witness?
Video strong.
Is it a known person? Because we have priors with Ms. Agbasieli and there are assaultive and, pretty dangerous priors. Any of the same complaining witnesses?
Does not appear so, Your Honor. I'm looking through. No, Your Honor. It seems like it's just, from what we can see, it's kind of just.
Was it a street worker? Was it someone working for the city or
It's someone that lives there, Your Honor.
just out there fixing the potholes?
That's correct, Your Honor.
Okay. All right, Ms. Agbasieli, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand, ma'am?
Yes, Your Honor.
Okay. Do you have the ability to hire a lawyer, ma'am?
Yes, Your Honor.
Okay, we can give you time. So what I'll have you do now is I'll have you sign a receipt, Victoria, while you take a seat, while we draft the bond conditions, I'll have you sign it.
Yes, Your Honor.
Please, ma'am, don't pick up any new cases. Just don't have contact with these people. I don't want to have to put you in jail,
Your Honor, it was the same thing the last time, the
Just,
last case.
just please be careful,
Yeah.
Really.
People make false allegations all the time.
And I get it. There's always 2 sides to the story. That's why you have a lawyer. That's why we'll give you time. But the evidence will point to whose side is correct.
Yeah, and I do have them.
So, please. Good morning, Mr. Kyles. Sir, you're charged with deadly conduct. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 2nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched to an apartment complex and spoke to a complaining witness who said that she was laying in her bed and was awoken by her son, the defendant, screaming. And then she heard 2 gunshots go off in the apartment. The complaining witness then got out of bed and took the gun from the defendant, hid it, and called 911. Upon arrival, the law enforcement officer recovered the weapon, along with 2 fired shell casings and 2 fired slugs matching the caliber of the pistol fire. Upon contact with the defendant, the law enforcement officer noticed the odor of alcoholic beverage and that the defendant was wet while fully clothed. The defendant stated he had
So, defendant was what?
wet while fully clothed.
wet while fully clothed, okay?
Your Honor. The defendant stated he had been drinking alcohol and smoking marijuana and that he fired the firearm in the apartment. The defendant stated he was wet because he dumped a bucket of water on himself. The defendant stated that he was paranoid at the time.
Okay, let's break down what we just heard because this case is wild. A mother is awakened by her son screaming and then hears 2 gunshots go off inside their apartment. Not outside, not in the distance. Inside the home where people are sleeping. The mother had to physically take the gun from her own son, hide it, and call 911. When officers arrived, they found the weapon, 2 fired shell casings, and 2 fired slugs matching the pistol's caliber. And the defendant? He admitted to drinking alcohol and smoking marijuana before firing the weapon. Oh, and he was wet while fully clothed because, according to him, he dumped a bucket of water on himself and stated he was praying at the time. I'm not even sure where to begin unpacking that explanation. This is what the court calls deadly conduct, recklessly engaging in behavior that puts others at risk of serious bodily injury or death. Firing a gun inside an apartment while intoxicated, that's textbook deadly conduct. The judge is now sending him for a drug test, ordering no weapons possession, and making it clear that substance use violations won't be tolerated. And here's the concerning part. When pretrial tried to contact the mother about whether she wants him back home, she refused to talk about the incident. What do you think is going on in that household?
Mr. Collins, I'm sending you for a drug test. I want to know what, if anything, is in your system. You're to come right back. I will appoint you a lawyer today, but you're not to use alcohol or illegal drugs. If I find that you're using, it's not going to go well for you. You're also not to be in possession of weapons. Do you understand? So, do you guys have a rip done on this case? Do we
Yes,
know
sir.
whether she wants him back at home or no?
I made contact with the claimant, Your Honor. However, she did not wish to talk with me about the incident after.
She want to talk to you?
No, Your Honor.
Okay. Don't be in possession of weapons, Mr. Kiles. You know, I don't want to have to put you in jail and make your bond high. I don't know if you have anyone in this life that is prepared to pony up $5,000 to $10,000. So when you're out there in the free world, if you don't have anyone that's going to, you know, pony up that money for a bond, you'll be stuck like Chuck in there. So be careful. All I want is my city safe. Do you understand?
Yes, sir.
Okay, so what we'll do is I'll appoint you a lawyer today. Or do you have the ability to hire a lawyer, or would you like a court-appointed lawyer?
You can appoint me a lawyer, and I may consider hiring one if the understanding is not
I
understood.
just want to know whether you want a court-appointed lawyer or not.
Yes,
I
sir.
can
Yes,
appoint
sir.
you a lawyer today. I'm sending you for a drug test. I want to know what, if anything's in your system. Come back, and then I'll have a lawyer waiting for you.
Okay.
Okay, please.
The financial affidavit or no?
I'm here on Katrina Keys. You had her on docket for Friday for a bond violation, but she needed to come in and talk to you anyway, so she came today.
I'm sending you for a drug and alcohol test right now, ma'am. But unacceptable. You're on bond for DWI, and you now you're allegedly consuming alcohol.
No.
Yeah.
I spoke with the SCRAM people and she said that was not it. It's not an alcohol violation. She doesn't know if
Alcohol was detected during both tamper events. But they cannot be confirmed because of the nature of the tamper.
I haven't had a drink since I was arrested, Your Honor. I've done everything this court has asked me to outside of looking for a job and everything. I have had no problems. I've called SCRAM about my device because I have neuropathy swelling. Once it goes down, so she said it was loose. I asked them. The only thing that I did on Saturday and Sunday, which can be confirmed by my GPS monitor, I went to my son's basketball game. I left my house, went to my son's basketball game, from the game back.
Let's
I
do
have
this.
not done anything.
Lisa, do you mind sending me for a test right now, please? I'm going to send you for a test. You
Okay.
come back. Do you
No problem.
understand?
Mhm.
We'll deal with the violation when you come back.
Okay.
Just please take a about it.
You can just. For the DVR?
No,
Oh, sorry, her drug test was presumptively negative, Judge.
ever test positive again, I'm going to keep you.
Judge, it was a SCRAM temper.
If you ever tamper with the device again, I'm going to keep you. I'm doing everything in my power not to revoke your bond. Do you understand? I don't care what it is. If there's a problem with your device, you need to go have it switched out, go get it looked at, but I will not entertain any more excuses from you. No tolerance. Do you understand?
Yes.
Okay, all right.
Did she address my, curfew? My lawyer was supposed to ask her about my curfew because I got a job and I started today. And the job is from 5 p.m. to 6 a.m. at Adrian. And I have the letter saying that I've been accepted for the job.
Now, this case shows just how complicated life becomes when you're on bond with monitoring conditions. Let's break down what's happening. This defendant is on bond for DWI. She has both a SCRAM device, which monitors alcohol consumption through sweat, and a GPS monitor tracking her location. Now, there are tamper events showing the device wasn't reading properly, and alcohol was detected during at least one of those events. She's claiming she has neuropathy, a condition that causes swelling, and that the device was loose. She says her GPS can confirm she only went to her son's basketball game and back home. And here's where it gets even more complicated. She just got a job. Her first job since being on bond. But the hours are 5 p.m. to 6 or 8 a.m. overnight shifts. She has a curfew as part of her bond conditions. She's already on probation for a prior DWI and has an open DWI case. The judge is clearly frustrated. I'm doing everything in my power not to revoke your bond. But the message is crystal clear. Any device issues need to be addressed immediately. No excuses will be entertained. And any deviation from the work route will be her third bond violation. I will deem you a public danger and make your bond sky high. This is the tightrope defendants walk when they're on monitored release.
Does she have something open elsewhere as well?
She had a deed open at Austin County, Your Honor.
Still open?
It's not still open. I'm not sure if she pled it or what happened, but looks like she's on probation now. For that one at Austin County.
You're on probation for DWI. You've not picked up another DWI. I don't want you driving in the middle of the night.
I'm not driving. I'm not driving.
That was just on March 26th, I believe, Your Honor. Is when she pled for when that case was resolved. The year probation.
I resolved that case. And I
You still have an open DWI and you picked up another DWI.
I didn't. I haven't done anything since before.
Don't talk. All I know is that you have a probation for DWI, you have an open DWI. The last thing I want is another death on my streets. And I'm going to do everything in my, I tell Pete, everybody tells me what I want to hear here.
I'm not.
And then when they get out there,
Before I took the job, I spoke with my lawyer. I
keys.
have someone that works there and they shuttle and I can get a ride. But right now, like I'm having a problem with getting my lights were turned off. The phone was turned off. I'm worried about monitoring. So I've been working very hard to find a job. This is the only job that I found and I need to work to survive, to pay my bills. I have to work. And with the background that I have, it's been hard for me to find a job regular 8 to 5. This is the only thing that was available. And then I made sure that there was a ride or a shuttle. They work in shifts. So 5, 6 people in my neighborhood work there. So I've secured a ride to and from work.
proof of employment that you actually have a job working
I
there.
have it. My lawyer have it and I have the
Have
email
you
right
get
here.
with your lawyer. I want to see actual proof that you're working there. And then we'll put a GPS monitor on you,
I have a monitor. I have GPS monitor already.
exact address, so that we know that you're going to and from work. If you deviate in the slightest, and I don't care what it is, that'll be your third bond violation, and I'm going to lock you up. I will deem you a public danger and make your bond sky high. Do you understand?
Yes.
Okay.
The-
Excuse me, I'll have you get with your lawyer and then they can get with pretrial.
And I start today. It starts today at 5 p.m., which is why she had to come today.
Okay.
So-
I'll have you get with Ms. Freedy. She can get with pretrial. You guys can work out the details.
All right, thanks.
Judge, would you like me to email that proof of employment to you or to pretrial?
No, to Felicia. And I don't know if you have her email address. I'll see if I can get it for you.
Okay, please. I'll see if I-
Give me a second. I'll chat it to you. Hold on. a
Okay,
second.
thank you, Judge.
Good morning, Mr. Williams. Sir, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On July 15, 2024 in Harris County, Texas, a defendant was observed on surveillance video entering a pawn shop accompanied by a female, a toddler, and a baby in a car seat carrier. The defendant was observed putting down the baby, picking up a projector, and concealing it behind an item on the next aisle. The defendant then returned to the baby, picked up the baby, and then picked up the hidden projector and concealed it in the car seat. The female completed a transaction at the counter, and the defendant left with the item in the car seat without paying, passing all points of sale. The defendant was identified by his Tennessee driver's license photo by the complaining witness. The value of the item stolen was $2,000 or $2,099.99.
Okay, this case just took a turn that I was not expecting. Let me make sure you caught every detail here, because it's wild. The defendant entered a pawn shop with a female, a toddler, and a baby in a car seat carrier. He puts down the baby, picks up a projector worth nearly $2,300, hides behind another item. Then he goes back to the baby, picks up the baby, retrieves the hidden projector, and conceals in the baby's CAR seat. The female completes a separate transaction at the counter, probably to make everything look normal, and he walks out with a stolen item hidden with the infant. All of this captured on surveillance video. He was later identified through his Tennessee driver's license photo. But here's where it gets even worse. This case is 220 days old. The defendant has missed court on 3 different occasions. Bond was forfeited at least once, maybe twice. The judge is done. Excuses go in one ear, go out the other. Actions are what matter. And the warning is crystal clear. Miss court again, and the bond goes so high it hits the clouds. Using children as props in theft schemes while simultaneously dodging court dates? This is exactly the kind of case that makes judges lose patience fast.
Do we know if they got it back?
I do not, does not say in the DIMS. We need just a moment, Your Honor, to.
We can worry about it later.
Yes, Your Honor.
Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to this pawn shop. You've also missed 3 different times. If you miss, excuses go in one ear, go out the other. Actions are what matter, Mr. Williams. You've missed court on 3 different occasions. If you miss again, I'm going to make your bond so high, it's going to hit the clouds. Do you understand? Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll take a look to see whether you qualify. Okay. You get, every time you bond out, they give you paperwork telling you where you need to go, the date and time and the location. So I'm not going to argue with you, man. It's just, we've had 3 different occasions. Your case is 220 days old. So I'll have you fill out an application. I'm going to have you sign a receipt. I'm going to have you take a seat, but I need to do further bond conditions on him. So you're not allowed to leave until we do further bond conditions. Please, please.
We're approaching on Sean Williams. He's on today's docket.
This is the gentleman, it's a theft of the projector from, okay.
Victoria told me I needed to approach about bond conditions,
Said you wanted more bond conditions.
but if you're happy with them all,
Well, no, the thing is this case is super duper old, right?
yes. And the judge, this was a 2B. And so that's part of the age. And then,
If it's a true 2B for
Well-
like 180 days, then I don't have a problem. But if he's been on bond
Well-
and then he takes off for 150, then
so just my brief look at it, what looks like happened is it was a 2B. He got picked up. He paid an out-of-county bond. And his next court date was not clear to him. And
come on.
so, he did bond forfeit. And then he paid another out-of-county bond and he's here today.
Yeah, he's forfeited at least 2 different times. It's now 212 days old.
It looks like to me, he's only bond forfeited once.
He's made,
And again, any amount of bond forfeiting is bad, but
discovery complete on this case?
Hold on, Your Honor. Verify that.
If you ever take off on me again, Mr. Williams, you know what's going to happen to the bond. And if you don't have anyone in this world that's willing to pony up 10,000, perhaps 5 to 10,000, you will be stuck like Chuck in there until this thing is over. Do you understand me? The only thing in this world I'm asking you to do is keep my county safe and show up. You pick up another case, you are unsafe to my county. It's really not going to go well for you. Do you understand me?
Do believe this, Your Honor, there's,
I'd like you to do a writ first as well to see whether they got the projector back or not.
yes, Your Honor.
And then,
Judge, if we can just have a regular reset,
your regular reset.
that'll give me time to look at
You
everything.
must be here at the next setting, so we're going to decide what we're going to do with this case. But I'm going to tell you now, if they didn't get it back, it will be part of anything. That
Understood.
restitution is, all right, Mr. Williams, don't have any contact with these people, don't have any weapons, don't pick up any new cases. So I guess, Felicia, I'll have you do it as just because it'll be faster so we can get them out of here. Just no contact with the complaining witness, no going back to the pawn shop, no new cases, no drugs, no alcohol. Okay, all right, dude. Good luck. See you in 30.
Okay. Okay, so I have talked to pretrial in regards to the violations as to tampering with the SCRAM.
You need a translator anyway, right?
I guess
Vicky
so.
Ramirez?
Yes. So, pretrial doesn't know exactly what was tampered with. He does work in construction. He wears boots, he wears socks. He does suffer from this condition called neuropathy, where he has to put like this cream on here. He says that SCRAM actually has been causing him a lot of pain on his legs. So sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no like BAC, no alcohol, nothing. It was just
Because a
tampering.
lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor to, evade. This is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 a.m. so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
See the first one,
And it says
began
alcohol was
at
detected.
on March 1st at 4:32 a.m., returned to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Come up, Mr. Ramirez.
I don't see the second one. I see the one on the first only.
Tengo que te estás, que tienes alcohol en tu sistema y que estás fallando con la máquina también.
No, sir.
La máquina me dice otra cosa. I don't know what to tell you, Ms. Solis, but
oh, I mean, pretrial doesn't have knowledge as far as like what was tampering. I mean,
they can't. It's impossible.
I know that, Judge.
It is, all we know is that the device is not detecting his skin for a certain period of time. And at the same time, alcohol is detected.
¿Dónde estabas el día primero y el día 8?
So let's do this. I need to get a translate here so I can properly translate and let him know what I'm going to do. Oh, Blasa.
Yes.
Can I borrow you for a second, please? I just need you to help me translate.
Oh, okay.
Mr. Ramirez. You were instructed not to tamper or remove the device. We have 2 tamper events here, where on March 1st at 6:33 a.m. and the second one on March 10th of 2025 at 11 a.m. Alcohol was detected on the first event alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
I know, Judge. I mean, we're ready for plea today, but
up your bond. You're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send it for a drug and alcohol test right now and he'll.
yeah, Judge, yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back. And we'll see.
Yeah, because he does say,
And that is a wrap on one of the most intense courtroom sessions we've covered. Let's break down what we witnessed across all of these cases. First, Juan Jose Serna, the repeat car burglar with a criminal history that reads like a novel. Over 20 charges, including multiple burglaries, thefts, assaults, robberies, evading arrest, and felonies. The judge's words were haunting. It's either dead or 50 years. Home confinement, ankle monitor, SCRAM device. The court threw everything at this case. Second, the terroristic threat case where someone made finger guns at neighbors who were fixing potholes, saying, "I'm going to shoot you." It sounds almost silly, but in Texas, that's a real criminal charge if the victims believe the threat was credible. Third, Mr. Kyles fired 2 gunshots inside an apartment while intoxicated on alcohol and marijuana. His mother had to take the gun from him and call 911. When asked if she wanted him back home, she refused to discuss the incident. Fourth, Katrina Keys navigating the impossible tightrope of bond conditions with a SCRAM device, GPS monitor, curfew, DWI probation, and a new job with overnight hours. The judge made it clear. Any deviation means her third bond violation and being deemed a public danger. Fifth, Sean Williams and his $2,300 projector theft, where he used a baby's CR seat to conceal stolen merchandise. Case is 220 days old with multiple bond forfeitures. Sixth, Mr. Ramirez with SCRAM tampering events and alcohol detection while having no immigration status, meaning jail could lead to an IC hold. The common thread? The court's patience has limits. Monitoring devices, bond conditions, and court dates aren't suggestions. They're the difference between freedom and incarceration. If this breakdown opened your eyes to how the criminal justice system really operates, smash that like button and let us know in the comments. What case shocked you most today? Do you think the judge was fair with these conditions? And what do you think should happen to chronic repeat offenders? Don't forget to subscribe and hit that notification bell so you never miss another jaw-dropping courtroom breakdown. Share this video with someone who needs to understand what happens when you push the legal system too far. Until next time, stay safe, make smart choices, and remember, the courtroom is where consequences become real. Peace.